everyone. Good afternoon. Welcome to today's Comparative Public Law Research Forum seminar. Delighted to welcome you all to today's seminar, and delighted to welcome our speaker, Professor Rehan Abeyratne, to deliver today's talk. So Professor Abeyratne is a professor and associate dean at Western Sydney University's School of Law. His main research area is comparative constitutionalism, including a regional focus on Asia. He's working on a book titled From Cosmopolitan to Self-Preservation: Courts and LGBTQ Rights in the 21st Century. And that's forthcoming with Oxford University Press. Before moving to Sydney, Professor Abeyratne was a member of the CUHK Law faculty for 6 years and served as executive director of the Centre for Comparative and Transnational Law from 2020 through to 2022. He is greatly missed, but we are nonetheless delighted to welcome him back to give this talk for us. There will be time at the end for questions. Just to say, please send any questions that you have to me directly via the chat, and then I will put them to Professor Abeyratne. So please send any questions you have to me via the chat function, and then I will read them out. Great, thank you. Well, without further ado, over to you, Professor Abeyratne. Thank you.
Great. Well, thanks very much, Professor Hamid, for that generous, warm introduction. It's great to be back, albeit virtually, at CUHK. Nice to see various colleagues. Hi, Kevin. Hi, others. Great to see everyone. I also want to thank Bonnie, who I know does a lot of work behind the scenes and, as always, organized this seamlessly. And I want to thank Professor Anatole Boot for originally inviting me to do this. Let me go ahead and share my screen. Okay. So as Professor Hamid said, I'm going to present basically an overview of my forthcoming book, which is called From Cosmopolitan to Self-Preservation: Courts and LGBTQ Rights in the 21st Century. Let me begin with a bit of background before I get into sort of the main claims and approach that the book takes. So the book started the book project, I should say, started a couple of years ago through, I would just say, an observation that I had, and I don't think I was unique in having this observation, which is that over the last 20 or so years, we can observe two major trends in global constitutionalism. Right? These are not universal trends by any means, but I think they certainly exist, and they exist in enough places that they've been reported on pretty widely, not just in kind of academic scholarship, but in the popular media as well. I think these will be familiar to most people, even if your area isn't constitutional law or comparative constitutionalism. So the first is, we might say that liberal constitutionalism has been in decline, right? If you want to be more positive about it and sort of characterize it more as a short-term phenomenon, you might say it's in recession, right? Which suggests that it might then kind of come back up. But however you describe it, it's pretty clear, I think, since around 2005, that sort of the level of democracy has declined around the world, and correspondingly the level of liberal constitutionalism, by which I mean the protection of fundamental rights, right, either through political means or through judicial means, has also declined within jurisdictions, right? So I'm not so concerned with international human rights, though there's probably a similar story to be told there. I'm concerned with domestic constitutional rights. So just kind of one indicator of this, the VDEM Institute puts out yearly reports on the state of democracy in the world. And the 2023 report says that the level of democracy that people sort of experienced around the world this year is the lowest that it's been since 1986. And that in recent years, the region that's sort of regressed the most on this score is the Asia Pacific, right? And I think the case studies that come to mind would be places like India, which is one of the case studies in my book, and I'll get to, Indonesia, the Philippines, and you go on, right? Another interesting finding from this year is that there are more what the report classifies as closed autocracies than there are full democracies for the first time in 20 years. So a full democracy is one in which there's not just kind of liberal constitutionalism, but there's a functioning democratic system of government, free and fair elections, and so on. A closed autocracy is the other extreme, which is there is sort of centralized power exercised in an authoritarian way, and there aren't even elections, right? So a slightly less advanced version of autocracy they call electoral autocracy, right? Which is maybe something like Singapore, where you have a pretty authoritarian state, but at the end of the day, there are elections and they're at least somewhat free and competitive. So that's sort of one story, and I think that story has been widely told. Another story, and a much happier story, is about the rise and protection of LGBTQ rights, right? So at the turn of the millennium, in 2000, no country in the world, for instance, recognized same-sex marriage. Right? The Netherlands passed a law recognizing it in 2000. This came into effect in 2001. And today, 34 countries now recognize same-sex marriage. So as I said, this is not exactly a universal phenomenon, right? There are 200-something countries in the world, and only 34 of them recognize same-sex marriage, but it's going in that direction, right? And several other countries also recognize civil unions, or some give some kind of legal recognition to same-sex couples, even if it's short of or different than marriage. Similarly, not that long ago, much of the world criminalized homosexuality or homosexual conduct, and now most of the world does not, right? This is another sort of major change that's happened over the last 30, 40 years. So just to kind of demonstrate these two things visually, so these two graphs are about democratic decline. The one on the left is from the Freedom House Index, right? And so for each year from 2005, it tracks the number of countries that have sort of improved in their democracy and the number of countries that have declined. So you can see in 2005, more countries improved than declined. But in every year since, it's been the opposite, right? More countries have declined than improved. The figure on the right is from that VDEM report I mentioned earlier. So the countries that are dark red are sort of the most authoritarian. The countries that are dark blue are the most liberal and most democratic. And you can see there's a lot of red there, right? Quite a lot of red, especially when you get into Africa, Eastern Europe, and Asia. There isn't a whole lot of blue, right? And so that's sort of, I think, a good representation of how fraught the state of liberal constitutionalism and of liberal democracy is today. Now, a quick visual representation of the other trends. So the one on the left is a graph from, or a map from 2022, showing this legal status of homosexuality worldwide. So the countries in green are where it's legal, right? And you can see that's most of the world, right? It's not just the so-called global north, right? It's all of Latin America, pretty much, most of Asia, even decent chunks of Africa. It's really just kind of North Africa and the Middle East, which is the exception. With same-sex marriage, it's less of a clear story, right? Or it's less of a global story. Here it is more the global North sorts of countries that have recognized it, though I would add that Latin American countries have started to recognize same-sex marriage increasingly over the last few years. There are a smattering of others, including South Africa. Taiwan is the only jurisdiction in Asia at the moment that recognizes same-sex marriage, though, as I'm sure many of you know, Hong Kong is on its way to doing so, or at least we think, and South Korea appears to be on its way as well. All right, so that's kind of the big picture that I'm working with. And so if you put these two things together, you might ask yourself, and I did ask myself, how can it be that these two trends exist simultaneously, right? They do appear to be at odds. So how can it be that liberal constitutionalism on the one hand is in decline, right? Basically, almost universally. And yet in quite a few countries, right, the constitutional rights of a historically marginalized and disfavored group, the kind of group that liberal constitutionalism tends to favor, is on the rise, right, are expanding. And so my book tries to provide a limited answer to this question, right? And it's limited in a couple of ways, right? It's a very, very big question. I don't plan to, and I don't think you'd have the ability to sort of make global generalizations about what's going on. So I'm looking at it in the context of judicial decision making, right? So societies where much of the constitutional rights protection happens through courts, including the protection of LGBTQ rights. And I'm looking at 3 societies in particular. So this is not a global study where I aim to give a universal answer. And I don't consider countries or jurisdictions where much of the progress on LGBTQ rights has happened through non-judicial means, right? So for instance, in most of Europe, much of the progress has happened through legislation. That's terrific. So it's not the subject of what I'm looking at. In some places, there have been referendums on major questions, right? So for instance, Australia and Switzerland both got to same-sex marriage through a referendum. Not looking at those either. I'm looking at places where the progress has happened primarily, not exclusively, but primarily through courts. 3 case studies in particular, right? The US, India, and Hong Kong. And you can see in my visual representation, I've given you the highest courts in those 3 jurisdictions because my focus will be primarily, though not exclusively, on the apex courts of those jurisdictions. So that's the US Supreme Court at the top, the Indian Supreme Court on the bottom left, and I'm sure the bottom right one is familiar to everyone here, the Hong Kong Court of Final Appeal. So let me just say a little bit about my approach and then get into the actual claims of the book. So as I said, the focus is on apex courts to keep things relatively consistent across the board. I'm using an approach that Rehan Herschel, who's one of the sort of leading figures, especially on kind of methodology in my field, calls concept formation through multiple description. And the idea is we're trying to generate an analytical framework, right? So the book will try to generate an analytical framework for thinking critically about constitutional norms and practices, focusing on a single practice as carried out in multiple jurisdictions. So the single practice here is the adjudication of LGBTQ rights within this context of declining liberal constitutionalism. The different jurisdictions are the United States, India, and Hong Kong. So that's kind of what I'm sort of going for. Let me just say a little bit about why I chose these jurisdictions. Basically, I wanted to choose jurisdictions that were relatively similar in the ways that they actually were going about adjudicating and progressing LGBTQ rights, while having enough sort of distinct characteristics to lead to a more kind of nuanced and I would say slightly broader analysis. So to start with what they have in common, so all 3 have written constitutions with fundamental rights enshrined therein. They are not all democracies, right? Hong Kong has never been a democracy, right? It's a hybrid state. It's now something, maybe still hybrid, maybe not. India and the US too, at best, are very flawed democracies, right? If you remember my map from a couple of slides ago, India is now actually considered an autocracy. So I'm not going to sort of make the case that they're democracies or not. In my view, they're at best flawed or partial democracies. They're all sort of hybrid-ish at this point. What they do have, though, as I said, are written constitutions. They have fundamental rights that are enshrined, and they have courts that, at least until recently, have tried to take those rights seriously. They are all common law jurisdictions, right? So all were once British colonies. Their courts, I think, have remained relatively independent, and their courts all have the power of judicial review, what Mark Tushnet has called strong form judicial review, meaning they have the power, though they don't have to necessarily use it, to strike down laws or executive regulations that violate the Constitution. And they all sort of fit the paradigm that I'm looking at, which is they've all experienced a decline in liberal constitutionalism and the protection of constitutional rights on the one hand, while courts in these jurisdictions have continued to recognize LGBTQ rights at pretty much the same time. There are, of course, differences between these jurisdictions, right? I mean, as is obvious, they're from different regions, right? A lot of comparative studies will look at sort of cases from a similar region because then you kind of hold culture consistent, or at least relatively consistent. You can look at other things. I'm not trying to hold culture consistent. I actually think it's important to look at different judicial cultures and just different cultures. So we have one case study from North America, one from South Asia, and one from East Asia. And there's various courts, including their Supreme Courts, or in Hong Kong's case, Court of Final Appeal, have distinct judicial cultures. I'm not going to get into this in too much detail, but just very quickly, the US Supreme Court is usually classified as an attitudinal court, which means that the judges are often trying to maximize various, if you're being cynical, you can say policy preferences, but at least they're sort of judicial preferences, and they're quite individual in their kind of ideologies. The Indian Supreme Court has been characterized as instrumental, which I think is a good term for it. And this is to say that they're not a very legalistic court. They care much more about the consequences and outcomes of cases than they do about following procedures or even following precedents. So it's very much law is used as an instrument towards various ends. Sometimes they're good ends, sometimes they're not. In Hong Kong, the Hong Kong Court of Final Appeal, I would characterize, and I think others have characterized, as a relatively collegial court, right? This is not a court where you get like stinging dissents very often, right? You tend to get unanimity, and even when you have divided judgments, they tend to be pretty moderate and hew pretty closely to the law. Each of these places also faces distinct challenges to liberal constitutionalism, which I think makes the story a bit more interesting. So in the US, the challenge, I would say, I mean, there are many challenges, but the big challenge I would say is partisan polarization, right? So you have kind of the two major parties, the Democrats and the Republicans, going further and further to polls. And in particular, it's an asymmetric polarization that's happened in the US, where the Republican Party has moved very, very far to the right. And has basically become an extreme and in many ways undemocratic small d party. And I think that's the big threat. Donald Trump is the obvious face of that, but it's a deeper problem, I would say, than just him. In India, it's ethno-nationalism. So the current government under Narendra Modi, which has been in power since 2014, is one that is quite openly committed to turning India into a Hindu nationalist state. That means a state that serves the interests of and really represents the Hindu religious minority to the exclusion of other minorities, especially the Muslim minority. Okay, and so this is kind of a big change in India, which had been imperfect for sure, but more of a kind of pluralistic liberal democracy prior to Modi. And then in Hong Kong, we see sort of the post-NSL authoritarianism that's come in, notably the electoral changes that happened a few years ago that have made the LegCo much less representative than it was, and other changes that have followed since. So each one faces distinct challenges. And so the idea with choosing these case studies is, right, so they've all experienced a similar phenomenon. Court-led advances on LGBTQ rights and otherwise not great times for liberal constitutionalism. But because it's happened in distinct cultural and political environments, you can develop a single analytical framework and then use it, hopefully, to say interesting things about each jurisdiction, right? So the idea is to generate more critical and nuanced analysis of what's going on in each jurisdiction with the same overarching framework. So now let me get to the aims of the book. And I would say I have three aims. I think that the first two are the majority of the book. The third one, I'm still kind of working through and I might get to it in the conclusion. But it's there and it's something that I hope to do. So the first one is kind of a descriptive claim, but I think it's actually an important descriptive claim to make and to make in detail and in context-specific ways for each jurisdiction. And that is sort of how exactly have these LGBTQ rights decisions been made? What were the factors that went into them? What was the outcome? And how does that fit in the broader story of the decline of liberal constitutionalism in these societies? Second is to set out an analytical framework to understand why they were decided that way, right? So what is the role of these cases in these specific contexts? And third, to unpack the normative implications of this phenomenon, right? So is this exceptional treatment of LGBTQ rights a good thing? And if so, under what circumstances and for whom? So I'm going to try to sort of disaggregate that in the book, and I'll do that towards the end of this presentation today. So let me say something, let me start with a descriptive claim. In the interest of time, because this is quite detailed for each case study, I'm not going to do it for all three. I'll do it for the US. And then if folks have questions about the others, I'm happy to take them in the Q&A. So the overall descriptive claim is this, right? Which is that courts have advanced LGBTQ rights protection while they've overturned, pared back, or avoided ruling on other liberal constitutional rights. And so the claim, therefore, is that LGBTQ rights are distinctive, right? It's a site of progressive, or at least less regressive, judicial decision-making, as these courts have retreated elsewhere. So the US story is, I think, very familiar to Americans, maybe not so familiar to others, in terms of sort of their positive LGBTQ rights recognition. I'll just mention a few of the major cases and then sort of put it in some context. So the major cases I've sort of listed there. The first one is called Bowers versus Hardwick. This was a case from 1986 and a quite regressive judgment. So this is a case in which the Supreme Court of the United States upheld a ban on sodomy and basically relied on traditional values to do so. What's remarkable is not so much Bowers, but the case that came after it, which is Lawrence v. Texas, which was decided only 17 years later in 2003. The majority opinion in Lawrence, written by Justice Anthony Kennedy, not only overturned Bowers by striking down bans on sodomy, right, because of the impact that it would have on the gay community specifically, but actually said that Bowers was wrong the day it was decided. It was a rare situation where the US Supreme Court, or really any court, is sort of that critical of one of its precedents, and one that wasn't that old, right? It was only 17 years earlier. From Lawrence, we get sort of three more, I would say, classically progressive judgments, and then there are a bunch of others that don't quite fit the bill. The really big one is Obergefell, which I'll get to. There are a couple of others that I'll also mention. One is Windsor, United States versus Windsor, which was a judgment in 2013, where the Supreme Court struck down a law called the Defense of Marriage Act. And this was an act of federal law, so national law of the United States, that was passed in reaction to states developing same-sex marriage laws. And basically the federal government and Congress and President Clinton at the time, who was a Democratic liberal president, but agreed to pass this law, basically said, look, we're not going to recognize same-sex unions issued by the states for any federal benefits. So for instance, if you are a lawyer for the Department of Justice, right, the US Department of Justice, and you have a valid same-sex marriage, right, your partner doesn't get the spousal benefits that opposite sex partners would get from the federal government. So the Supreme Court struck that down, again in a decision by Justice Kennedy in 2013. The big one is Obergefell in 2015, which recognized same-sex marriage. Justice Kennedy, again, writing a very rhetorically strong, but maybe a bit jurisprudentially iffy judgment. And a year after that, or a couple of years after that, Justice Kennedy actually stepped down from the bench. For those of you who follow kind of judicial politics in the United States, there was a big shift in the court around then, because not only did Justice Kennedy leave, but Justice Ginsburg, who was either the most progressive or the second most progressive justice on the court, died during the final years of the Trump administration. And he was able to very quickly fill her seat with a very conservative justice named Amy Coney Barrett. And so the US Supreme Court went from being a relatively balanced court, having 4 liberal justices and 4 conservative justices with Anthony Kennedy in the middle, to becoming a very conservative court with now 6 quite conservative judges and 3 liberal judges, okay? And yet, they passed this judgment in Bostock. Now in Bostock, it wasn't quite 6-3 yet, but it was close. I think it was still, there were 5 strong conservative judges. And in that case, the majority opinion was written by Justice Neil Gorsuch, who was appointed by Trump, who's a well-known conservative judge. And it's not a constitutional case, exactly. It's a statutory interpretation case, but it has a similar effect. And effectively, that case read a civil rights statute called Title VII, an anti-discrimination statute, to cover LGBTQ people. Basically, gay and transgender people. That statute was written a long time ago, and it only bans discrimination on the basis of sex. But Justice Gorsuch read sex to cover sexual orientation-based discrimination and gender-based discrimination, right? Which was quite a progressive thing to do, though he claimed this was just sort of a clean textual reading. Okay. I don't want to give the impression that this has just been a kind of linear progression in the United States or in any of these jurisdictions. So as all this was happening, a few things need to be noted. One is, despite these progressive judgments, the US Supreme Court has consistently declined to recognize LGBTQ people and the LGBTQ community as a protected class under the right to equality, right? So racial minorities are a protected class, so women are a protected class, sexual orientation minorities or sexual minorities are not a protected class. And this is important because it means that they don't get, so laws discriminating against them are not held to the same level of scrutiny that laws discriminating on the basis of race or alleged to discriminate on the basis of race would. And I would say, just as importantly, the Supreme Court consistently, even when it was more liberal to now, has consistently held in favor of other rights when there's a conflict between sort of the rights of an LGBTQ person on the one hand and someone asserting another right, usually something that's sort of kind of core to the American identity, like the First Amendment, protection of free speech, free assembly, or the free exercise of religion. There are many cases like this where kind of the First Amendment has prevailed over an LGBTQ person. The most famous is probably Masterpiece Cake Shop, which was actually issued by Justice Kennedy, the very same Justice Kennedy who issued all these progressive judgments. And basically that case held that a baker who refused to bake a wedding cake for a same-sex couple, couldn't be prosecuted for that, right? And that his freedom of expression allowed him to say no to make a cake, to decline making a cake for a same-sex couple, even though that seemed to violate the state's anti-discrimination law. This was in the state of California, in Colorado rather, which had an anti-discrimination statute that prevented discrimination on the basis of sexual orientation. But the court said, well, but his freedom of speech trumps that. And there are many other cases like that. Okay, so it's not a totally, clear or totally progressive story, but I do think that LGBTQ rights in the US and in the other jurisdictions that I cover are unique because despite the kind of rightward turn of the Supreme Court, despite the political polarization that I said earlier, the major victories do appear to be safe. So there has been some talk that Obergefell, the same-sex marriage decision, will be overturned, but I really don't see that happening, right? Lawrence v. Texas, the homosexual ban, there's no way that's going to be overturned. And you can contrast this to what the current US Supreme Court has done on other liberal rights, right? So the right to abortion, which had existed since the 1970s, they decided to overturn last year. Voting rights, which are really central in the United States, have been gutted over multiple judgments by this conservative court. Race-based affirmative action, another really sort of central liberal right, was also overturned recently, I believe earlier this year, right? And so there is still something about LGBTQ rights that keeps them somewhat inured from this, or somewhat protected from this sort of rightward trajectory of the court and the polarization of the country. So that's the descriptive claim. As I said, there are sort of versions of that for Hong Kong and India, which I'm not going to get into. Let me move on to the analytical framework, right? So what are LGBTQ rights doing in these jurisdictions? And I think they're doing two things, right? Sometimes they're doing one of these things, sometimes they're doing both of these things. But I think that they enable courts to strategically advance the following objectives. Number one, to sustain a progressive rights agenda with minimal political backlash. And number two, to preserve what is left of their own reputation for independence, for impartiality in decision-making, to constitutional rights, and so on, in response to charges, sometimes valid, sometimes maybe not as valid, of political capture, of political silencing, and so on. So why minimal backlash? Again, it's a slightly context-specific question, and so the answer is a little bit different in each of the three jurisdictions, but basically the answer is twofold in my view. One is that I don't think LGBTQ rights are the primary, or issues, are the primary movers or political concerns of the reactionary political forces in these societies. So let me give the example of India here. As I mentioned earlier, Prime Minister Narendra Modi and his ruling BJP party are committed to this kind of Hindu nationalist project, and they formally oppose same-sex marriage, right? They formally oppose it. There's recently litigation in the Indian Supreme Court towards recognizing same-sex marriage. The court ultimately did not hold that there was a right to same-sex marriage. But what was very interesting is that the government volunteered, right, despite opposing it, right, and arguing vociferously against it in court, volunteered to form a high-level committee to look into the matter. Now, how honest they are about that, who knows, right? I assume they will form some committee. Maybe they'll just be for show. But the fact that they decided to do that, I think, is very interesting, right? And I think it's because this is where they can throw the courts and liberals a bone. Their main goal is to turn India into an autocratic Hindu nationalist order. And so their main policy prerogatives are things like something called the Citizenship Act, which kind of deprived immigrants from neighboring countries, especially Muslims, from citizenship. Laws that prevent interfaith marriage, right? To ensure that sort of Hindus are sort of remain kind of shall we say separate from the other religious groups, especially the Muslim minority. And so this is not a main area of their concern. They formally oppose it, but they're willing to kind of make some concessions like this for their own strategic needs, and because I think it's good for them as well to let the courts look at least somewhat independent on these issues. Another reason is that, the social movements in each of these places has been very effective, right? And we have to give the LGBTQ community a lot of credit for this. I think they've been very effective in raising the profile of their issues and increasing public support thereof. A really good example of this is a recent study published by the Center for Comparative and Public Law at HKU, along with a few other partners, which was a follow-up from previous studies they've done. So they did one in 2013, and they did another one this year. It's basically looking at public views of the rights of same-sex couples. And I'm just going to quote from the report. It says, in 2013, only a minority of Hong Kong people surveyed said that same-sex couples should be permitted to marry. Just over half of people expressed agreement with same-sex marriage in 2017, right? So just 6 years ago, there's bare majority support. You wouldn't even call that majority support really for same-sex marriage. But by 2023, 60% agreed with same-sex marriage. Only 17 said they did not support it, and 23 were neutral. Okay, and perhaps not coincidentally, then 2023 is also the year that the Hong Kong Court of Final Appeal ruled that the government must create a framework to recognize same-sex unions, right? And has given them 2 years to do that. Okay, so I think the sort of the work of these social movements and kind of raising public support has been very important in reducing backlash. Because again, if you're a government, you don't want to be seen as opposing something that solid majorities of the public support. And this is something that a solid majority of the Hong Kong people now support. So that's the backlash point. What about this reputational point? So each of the three apex courts I'm looking at faces distinct challenges to maintaining its reputation for structural independence and for impartiality in its decision-making. I'll just give the examples of the US and Hong Kong here. So the US Supreme Court in recent years, especially its more conservative members, have grown quite wary and in some cases quite angry about media commentary and some academic work that depicts the institution as partisan. Effectively, the judges are accused, I don't think incorrectly, of favoring the prerogatives of the Republican Party, right? And some members of the court, notably Justice Alito, has written sort of many op-eds kind of railing against this narrative. But rather than rail against the narrative, it's good to have something to counter it, like an actual decision, right? And so I think the Bostock judgment, right, the one in which a conservative Supreme Court, like with an opinion authored by a conservative justice, ruled to expand a civil rights statute to cover gay and transgender people, that's a helpful way to counter that narrative. Hey, you say that we just sort of favor the Republican Party. This is a, you know, not just a Democratic Party thing, but a really kind of a liberal victory that you know, that doesn't favor the prerogatives that you claim that we favor. In Hong Kong, there definitely are concerns about the diminished judicial review authority of the courts and the diminished sort of space in which they operate. The Lai Chi-ying judgment from a couple of years ago sort of confirmed this when the Court of Final Appeal said that they don't have the power to review the NSL, right? That they don't have the power either to conduct sort of constitutional judicial review or even a lesser form of common law judicial review, which is one of the things the advocates asked for. And so LGBTQ rights is an area where they can show that they are actually still independent, right? So Shamsa Kit, the case from earlier this year, is a really landmark judgment, right? For folks not familiar, it was a 3-2 decision, so five justices on the Court of Final Appeal, 3 in favor, 2 against, which said that by failing to recognize same-sex couples, right, to give them legal recognition, the Hong Kong government was in violation of its positive obligations under Article 14 of the Bill of Rights Ordinance, right? Article 14 relates to privacy and family. The Court of Final Appeal, as it does sometimes, rather than kind of issue sort of an order saying you must do this now, suspended the declaration of invalidity. And so the government has 2 years to establish a legal framework to recognize same-sex unions. Okay. So I've talked a lot about contextual variation in the context of my analytical framework. But from all that variation, I think we can see sort of 2 broad patterns emerging across the 3 case studies. One is that as kind of conservative forces have become more predominant, either on the court or in society or in both, that courts have shifted from a more positive to a more defensive posture, right? So from cases that were more sort of openly cosmopolitan, sort of, you know, really sort of ruling strongly in favor of the rights holders, to an approach that I would call more self-preservationist, right? More cautious and strategic, moving the law along incrementally, using things like suspended declarations of invalidity to make sure that the backlash is not too much and that the courts don't get sort of don't face too much blowback. Second, and I think perhaps more interesting, is that despite this change in substance, the language has remained very constant, right? So this cosmopolitan language of global constitutionalism, so, you know, paeans to human dignity and equality, these come out of these judgments. I think that's a good thing. I'm not against it. But it's just interesting that it seems that courts are using LGBTQ rights as rhetorical devices in some ways, right? To demonstrate their commitment to liberal constitutional values, even as their judgments have turned either slightly regressive in some cases, or at least more defensive and self-preservationist, right? And so I think this speaks to the sort of hegemony of that language, but also sort of the strategic way in which that has been used. So let me just end quickly, because I know we don't have too much time and I want to leave time for questions, with some normative implications of this self-preservationist turn, right? So what do we make of courts kind of now sort of doing the sort of limited, these limited progressive judgments on LGBTQ rights? So for courts, I think it really depends on the context in which they're in. So if liberal constitutional decision-making has really been restricted for the foreseeable future, you know, this might be the best they can do, right? So Shamsa Kit in Hong Kong, that's maybe about what the Court of Final Appeal can do. And so we have to be sort of realistic about that. If it's potentially a more short to medium term calculation, right? That, you know, so for instance, in India, the Supreme Court might think, look, Modi is there, but there are still elections. It's possible that he might leave or he might retire and there might be a different political coalition in power someday. Then, you know, this turn might be a kind of useful way to adapt liberal constitutionalism to survive the current moment, as long as the judiciary itself survives intact. In India, this is a problem, as the Modi regime has tried to undermine the court and appointments to the court in various ways. In the US, if it's a self-serving move, I'm not sure that it is, but if it is a self-serving move to cover up a partisan agenda, so hey, we're going to do all these terrible things, but occasionally do something nice on LGBTQ rights, then that's very troubling, right? And that's something I think we want to call out quite clearly. For the LGBTQ community, what can we say here? Obviously, progressive advances are good, right? But at what cost, right? One of the big concerns with court-led advances on rights in general, not just in this area, is that they're more easily reversible than legislative changes, right? You get something enacted in legislation, that tends to be stickier than a court judgment, right? You can have judicial personnel changes, especially in the US, where sort of there are these big shifts based on who's on the court. The strategic calculus for various reasons could change, and so you can see reversals of these rights that are only judicially recognized. The other thing is, sometimes when you rely on courts, you sort of get to what seems like an endpoint, but it's never entirely linear, as I showed in the US, and it's not necessarily teleological. So, for instance, same-sex marriage might not be the end. Literally, it may not happen in India, but in the US, I think a lot of people, especially sort of liberal-minded people, are like, well, we've won, right? I'm not saying necessarily LGBTQ community thought this, but liberal-minded people are like, we've won same-sex marriage, that's the end of it. But it's actually not, right? Of course, there are transgender issues that still exist. And even with same-sex couples, they're regularly denied other rights, like the rights to adopt children and so on, despite the big Obergefell decision, right? And so when you go with courts, you have to kind of keep fighting various battles rather than just sort of having one piece of legislation or a range of legislation that kind of covers everything. And so, depending on the situation, it might be a time to move away from courts, because courts seem to also be kind of paring down what they're going to do, even in this area. And finally, what does this mean for liberal constitutionalism, right? And this is quite tentative, because I think it's very hard to say. Lots of things could happen politically or judicially in these societies. But I don't think it's crazy to think that, this might be the last gasp of this kind of court-led progressive rights constitutionalism until some other paradigm takes over. It could be illiberal nationalism of various kinds. It could be, if you're optimistic on the political left, you might think it's a more kind of broad-based, less elitist kind of democracy, right, where things are decided in the public sphere a little bit less than in the courts. It might be the liberal constitutionalists are just, the paradigm is over, has shifted, and so they might just be locked out of power, right? And so maybe courts are the one way, maybe this kind of court-led way is the way to go. But I really don't think that elite judge-led progress on rights is a sustainable model, right? You do need to have some, I think, public support, which exists for some things like same-sex marriage, but may not exist for other rights in the future, unless there is some kind of political commitment to these underlying values and sort of more popular mobilization in favor. If you just have courts doing something that sort of is out of touch or out of line with what society is doing, that's then a recipe for backlash, and that's a recipe for the courts being defanged even more. So let me end there. Thanks again, and I look forward to questions.
Wonderful. Thank you, Rehan, for that absolutely fascinating talk. Lots and lots of questions that I have. Just to remind everyone, if you have any questions, please just send them to me in the chat, and then I can, of course, put them to our speaker. Just to kick things off, I might just ask a quick first question. So this category of LGBTQ, I just wonder whether you have sensed within the case law sort of some differences in treatment for some of those subcategories, as it were. The reason I say that is because in the UK, so a jurisdiction that I'm more familiar with, issues concerning trans rights, transgender rights, much more of a hot potato politically And, well, there may be a debate as to how far that's then influencing the courts and the judgment that the English courts are reaching. So I just wonder whether there's a sense in the jurisdictions that you've looked at that all of these groups are being treated in a certain way by the courts, or whether there are sort of distinctions between them.
There are definitely distinctions. I didn't bring them up in the talk, but it is something I get into in the book. So yeah, there are at least two different kinds of distinctions we might draw. One is between the sort of various subgroups within the umbrella of LGBTQ rights, as you just did, Asif. So right, so as you rightly say, I think transgender rights are very much politically salient, especially for reactionary forces now. Right. In the US, I think that's definitely true, maybe a little bit less so in Asia, but certainly true in the US. And so I think that is different than, say, something like recognizing same-sex marriage. There's also a difference in sort of what the cases are asking for. And so my sense, and, I need to sort of write this a bit more formally, it's something I have in mind, but basically, there are certain cases where, especially if it's, a law kind of policing social mores that's been around for 100 years, courts usually are more willing to strike that down, right? So Section 377 of the Indian Penal Code, which then kind of migrated to Malaysia and Singapore, even the Singaporean courts are like, no, we don't want this anymore, right? So I think, and the Lawrence case is like that. I think that's easier to strike down. Whereas with same-sex marriage, you're kind of, the courts are sort of providing affirmative recognition to a new right, or at least expanding a right in a way that's I think some of them feel is a little bit more of a step. The Indian same-sex marriage judgment earlier this year, as a formal matter, basically said that they didn't feel like they had the power to do that. They said that would have been effectively legislating from the bench. Now, whether they actually feel that, or whether that was a way of kind of passing the buck, I don't know, but it is worthwhile to note that they did say that, right? Whereas just a few years earlier, they were very happy to strike or read down Section 377 of the Indian Penal Code to decriminalize gay sex.
Great, thank you very much. So there's a bunch of questions that have
great.
Come in. So I'll just go. Shall I put one to you at a time?
It's up to you. If you think they can be grouped, I'm happy to take a group.
Sure. This first one's quite involved, so I might just put this one to you by itself. I'll just read this out. So this is from Stefano Osella from HKU. I would like to ask Rehan what he thinks of explicitly homo-nationalist narratives in Indian case law. So, for example, the NALSA and Union of India case on the third sex was criticized for presenting a saffronized account of gender diversity. And what Stefano goes on to say, in this sense, there will be no tension between the liberal dimension and the illiberal turn. And he's suggesting that the trans rights have been mobilized in a nationalist sense.
I think that's a great point. I totally agree with Stefano on that one. It's one of the reasons I didn't mention NALSA, because I think it's a tricky one. But you're absolutely right, Stefano. I think because, I think it's something that the Hindu nationalists have realized is, some parts of India's great diversity and pluralism can be used to their advantage. So not the fact that like Muslims and Christians have lived there for a long time, but the fact that, the Hijra community and other, non-binary gender groups have sort of coexisted in a Hindu community for a very long time. So I think that's a fantastic point, and I completely agree.
Great. Okay. Next question. From a former student of yours, it seems, Noble Low, a previous JD student, who says this was a very wonderful and inspiring seminar. Thank you so much. And the question is about the upcoming book. Will you consider including the UK alongside other countries, maybe, for comparison in your book?
Sorry, who's the student?
Noble Low.
Okay, well, nice to see you. Thanks. Oh, Pokan, yeah. Nice to see you. think in my comparative constitutional law class. So you've gotten some version of this from me before, I think, if I had to guess. Thank you for the question. I'm not going to include the UK. I think I like my 3 case studies. And I think many of the concerns animating the US are at least somewhat analogous to those animating at least the politics in the UK. I know the judiciary is different, so I'm going to resist that.
Great. Another question from Yufei Du. Thank you for the clear presentation. In both the US and Hong Kong, the court ruling for gay marriage came when the majority of public opinion had shifted in favor. Do you think they're still at risk of paradigm shifts?
It's a very interesting one. As I said, I don't really like getting too much into the prediction game because, you know, you're sort of often going to be wrong. But if you're going to push me, and I sort of did say this in the presentation, I don't think it's going to be overruled. Now, there are reasons to be concerned, though. So, you know, the very conservative justices on the US Supreme Court who were once, you know, kind of marginalized kooks, frankly, like Clarence Thomas, are now empowered. And he had this amazing, I think it was a concurring opinion, either last year or 2 years ago, where he sort of listed all the various kind of progressive court judgments that he wanted to overturn. And Obergefell was one of them. Now, he was not joined in that opinion by anyone else. So I suppose that's at least some comfort for now, but it is interesting that he did list Obergefell there. So I don't want to sort of come off as saying it's impossible and that like the narrative might not shift entirely. I just think that the Republicans have other things in mind. Again, as Asif rightly said, I think transgender rights are very much in their crosshairs now. I think, at least among elite Republicans, my sense is they think of same-sex marriage as something that's done and dusted, and then moving on to the next kind of culture war.
Great, thank you. I have another question. Oh gosh, that's my doorbell for some reason. Let me ask you the question. So if you mentioned at the very end of your presentation this worry that, you know, actually using courts and you know, seeking litigation as a means of trying to sort of, you know, protect yourself to advance your interests. There was a hint that there might be some worry about that. I think lawyers can sometimes think that, you know, are often led to think that using litigation as a way of enforcing rights and advancing causes and interests, you know, that's a very good way of doing so. But of course, you've highlighted some of the concerns in relation to this, and actually that using politics, you know, political sort of movements, political solutions might be the better way forward. So I'm just wondering if that's your sense as well of these things. I'll just turn off my video as well for a second.
Thanks for the question. I mean, that is my general view, but again, it's a little bit context specific, right? So, you know, if you're going to sort of advocate for political solutions to things, there needs to be adequate political space for people to organize and openly convince their representatives to make those changes. So, you know, I think, you know, to the extent that, you know, all these once democratic / hybrid jurisdictions are not quite as democratic or as hybrid as they were. You know, one of the reasons that I don't want to completely write off judge-led constitutionalism is that might be the only game in town in some ways. And so it's a bit of a contextual question. I think, you know, I think in the US, potentially, there's a little bit more room for political organizing just because you have a kind of loud civil society and you have multiple states where you can do different things. I think in India and Hong Kong, I would be less aver. So in the US, and I think the US Supreme Court is a totally partisan institution that we should kind of stay away from. But in India and Hong Kong, I think I'm a little bit more open to judicially led advances because, as I said, I'm not sure there's another game in town.
Great, thank you. So Chris says I don't think I can manage to put my question in writing, but if you can unmute me, I'm happy to ask one. Yes. Is it possible to unmute Chris? Let me see if I can find... Oh, there he is.
Aha, I escaped the mute wall once again. So thank you, Asif. Thank you, Rehan, for the fantastic talk. We have a few minutes. I'm going to ask a very big question. That will be difficult immediately. But I guess, my big picture, I guess, sort of one big picture question I always have in this area is, informed by the long history, sort of the 19th century history, etc., but also just this general question of why is it that for particular states and particular times and places, they seem to feel the need to, they seem to think it's helpful to their overall project to, limit the possibility of a same-sex marriage or penalize same-sex relationships, that sort of thing, right? So that, and I mean, I guess, to me, it seems like in order to fully understand, I guess in the first place, what moment we're in where it's possible for there to be some of those reversals of that kind of historic trend, we need to understand why, sort of what functions that was fulfilling. So I wonder what insights or thoughts you have about that. And I also wonder sort of, whether, so I know you focused on these 3 case studies, but do you think there are other places in the world where things are maybe going in the opposite direction? Or, I mean, is this sort of a universal movement, or other places where things are going in the opposite direction? And if so, maybe does that help explicate what types of state formation might be on the other side of the equation? So thanks a lot.
Thanks, Chris. A big question. I think one of the challenges of this project is that it's operating, and I think has to operate at multiple levels in terms of sort of trying to figure out what moment we're in. So on the one hand, I think globally, I think we're past the sort of end of history, liberal constitutionalism dominant paradigm. I just think that's true. And so I think to the extent that these courts and elites in these jurisdictions were once members or fans of that particular paradigm, I think that has left them by, that has passed them by. So part of me feels like, and I do say this in the book, part of me feels like this is the sort of, these are the fragmentary remains of that project. That is, it's the kind of one way that they can adapt that kind of elite transnational project to continue today. So I think there's that sort of that aspect. Then, of course, as you rightly say, there's the domestic aspect. And of course, it's different, right? Now in the US, depending on who you ask, and you know this, I mean, better than I do, the decline in liberal constitutionalism has been happening since at least the 1960s, if not like earlier, right? Whereas, in Hong Kong, it's probably much more sort of recent. And in India, again, it really depends on who you ask, right? It depends sort of who you feel like was benefiting from that project. Because even things that were once considered totally emancipatory, like public interest litigation, have now been reassessed as kind of elite to middle class sort of projects where the poor didn't actually benefit. So if you're going to take that lens, then even sort of the high point of liberal constitutionalism in India, which is usually like the 1980s, maybe not such a high point after all. So my view is, I'm interested in sort of the last 20 years, because regardless of where the decline, if you will, started, I think it was at least happening in that period, and happening in slightly different ways. So in the US, I think one of the big changes that happened after 2000 or so, 2005, is that the kind of global stuff, which was prominent in the 90s and early 2000s, even if we had moved way past the Warren Court, that was still predominant, but that then started to decline, right? Whereas, and in India and Hong Kong, I think sort of political changes in the last 10 years or so have precipitated that decline a little bit later. So I think your question just kind of makes me sort of doubly aware that I need to be sort of very contextually specific about what I'm talking about here, in terms of sort of which level of analysis and kind of what's happening in each country. But I hope that's a reasonable answer.
Brilliant. Thank you very much. Thank you once again, Professor Abeyratne, for your fascinating talk. Thank you to the admin team for organizing all of this. And of course, thank you to our audience for all of your attention and your really interesting questions.